National Council of Resistance of Iran, U.S. Representative Office. My name is Alireza Jafarzadeh, and I'm the Deputy Director of the Washington Office of the NCRI. Also like to greet our many of our online viewers who are watching us, because this event is broadcast live on all social media platforms of the NCRI-US office, but also on satellite TV, beaming into Iran and around the globe. As you can see, we have a very distinguished panel today, and consists of senior judges, lawyers, family members, victims of the crimes against humanity and genocide by the Iran regime's president, Ebrahim Raisi, who are now seeking justice. Last week, initiated and facilitated by the National Council of Resistance of Iran, a legal complaint was filed in the U.S. District Court for the Southern District of New York under the Alien Tort Statute, ATS, and the Torture Victim Protection Act against Ebrahim Raisi, the Iran regime's president, for his crimes against humanity and genocide. This is a very significant undertaking. It's a very unique one. It would be the first time that any court is actually building a case, a record, an investigation about the crimes against humanity and carried out by the regime's president, Raisi. It's also the first time that the Iran regime's president, Raisi, wants to come to actually a Western country, the first visit to any Western country. Something has been denied so far. Now, without further ado, I'd like to go to our speakers, introduce them. But before that, let me remind everyone that there are two main hashtags that people are using associated with this event. One of them is hashtag no visa for Raisi, and the other one is hashtag prosecute Raisi now. So let me first start to introduce the panel at the press conference here. To my right is Professor Stephen Schneebaum. He has been leading the cases regarding the Iran resistance for a long time, fighting so many different battles. And he is actually the counsel for the plaintiffs in the case that I just mentioned. To the right of Professor Schneebaum is Attorney General Michael Mukasey, who was the 81st Attorney General of the United States with impeccable track record. And he has also been very familiar with so many cases regarding the Iranian resistance, including many court challenges regarding the designation. And then to the right of Attorney General Mukasey, we have Ms. Suna Samsami, the U.S. representative of the National Council of Resistance of Iran. To her right is Ms. Sheila Neinawai. She's a former political prisoner in Iran who spent a total of 8 years in the Iranian prisons. She was arrested 3 times, and she appeared before the Death Commission, which actually included the current notorious president of the Iran regime, Ebrahim Raisi. To her right is Mr. Ahmad Hassani, who is one of the plaintiffs in the case and filed in New York. His brother Mahmoud was executed during the massacre of 1988 after appearing before the Death Commission. And to his right is Mr. Amir Borjkhani, another plaintiff in this case. He is also a former political prisoner in Iran. He spent a total of a little over 9 years in different spans. He also appeared before the Death Commission attended by Ebrahim Raisi. With that, I would like to ask our representative in the U.S., Ms. Suna Samsami, to please start and give us an overview about where we're standing politically as we're discussing this issue. Please, Ms. Samsami.
Thank you, Ali Reza. Good morning, everyone. The Iranian regime's president, Ebrahim Raisi, is planning to attend the UN General Assembly in September. It is our contention, and many others, that instead of hosting Raisi, the United Nations must hold him accountable for crimes against humanity and genocide. Anything less would be an affront to the principles and values that United Nations Foundation and Charter of the UN is founded. In the summer of 1988, Khomeini issued a fatwa that I have the picture of it in my right, ordering that all members and sympathizers of the Mojahedin MEK who remained steadfast in their support for the MEK must be executed at once. As a result, 30,000 political prisoners, more than 90% of them affiliated with the MEK, were hanged in a matter of 3 months. The death commissions, which were established by the clerical regime, carried out the fatwa against the defenseless prisoners. Ebrahim Raisi at the time was the deputy prosecutor and was a member of the death commission in Tehran, and was therefore personally responsible for sending thousands of the MEK prisoners to the gallows in Tehran and in the city of Karaj, which was near the capital. But his crimes are not something of the past. As the judiciary chief, Raisi personally oversaw the murder of at least 1,500 innocents crying for freedom during the November 2019 uprising. Raisi's record since assuming the presidency last year once again proves his criminality. 582 executions, including 22 women and 8 juvenile offenders in only 1 year, which is double the number of the previous year. Let me tell you that there are thousands of Iranian Americans living in the United States who have been victims of the mullahs in Iran. Either some of them spending years in prisons, some losing family members at the hands of the regime, and many are victims of Raisi himself. The National Council of Resistance of Iran and the MEK are calling for justice. Since the early days of the massacre in 1988, this campaign for justice will continue for accountability of Raisi. This campaign for justice will continue until the regime is overthrown and democracy and freedom is established in Iran. This lawsuit by the victims and their family members against Raisi is one step in this campaign for justice, which we will continue with the help of our compatriots until the criminal leaders of the regime, Khomeini and Raisi, are brought to justice. Thank you, and going back to Ali Reza.
Okay.
Thank you.
Thank you so much, Ms. Samsami. We're now going to Judge Mukasey, the 81st Attorney General of the United States, to give us both an overview about this whole case, but also in the big picture about Raisi, the challenges, the opportunities. And so let's hear from Judge Mukasey, please.
Thank you, Ali Reza. A year ago, in August of 2021, we had occasion to mark, if not exactly to celebrate, the accession of Ebrahim Raisi to the presidency of Iran as the hand-picked candidate of the supreme leader, Ruhollah Khomeini. Raisi at the time was already generally acknowledged by observers both inside and outside the United States as a stone-cold killer. The head of Amnesty International issued a statement when Raisi's selection was announced in June of 2021, expressing her consternation that such a person could be chosen for such an office instead of being investigated for crimes against humanity. In 2019, the U.S. Treasury Department's Office of Foreign Assets Control, known as OFAC, imposed sanctions on Raisi based on his participation in what has become known as a death commission, ordering the execution of thousands of political prisoners, including thousands of members of MEK, in 1988. And in 2021, the State Department, which may play a role in this case, imposed immigration restrictions on him based on a finding that he was a senior Iranian official involved in the commission of serious human rights offenses. Today we have occasion to mark yet another landmark, or milestone of sorts in the long career of Ebrahim Raisi, the filing of a complaint by some of the victims and relatives of the victims of the campaign of torture and execution that he helped carry out in Iran in 1988. The course that this case will be influenced by several aspects of the setting in which it's been filed. One, of course, is the legal setting. It's anticipated that if Raisi comes to the United States, as he said he will in September, to attend the UN General Assembly, in the ordinary course, and absent other considerations that I will get to in a moment, he would be subject to the jurisdiction of the United States courts and could be served with a complaint in this case, which presents claims under two federal laws, the Torture Victim Protection Act and the Alien Tort Statute. These laws are similar in that they allow for the filing of civil rather than criminal claims in U.S. courts, claims that allow plaintiffs to affix civil liability on individuals who act in an official capacity for any foreign nation to commit torture or extrajudicial killing of victims of any nationality, including victims who are of the same nationality as the perpetrators. Raisi here has been sued as an individual, but the acts he committed were committed in his official capacity as someone exercising powers given him by the government of Iran, indeed powers he exercised in carrying out that 1988 fatwa by the Ayatollah Khomeini himself. Although these acts were committed abroad in the exercise of official powers, there should be little doubt that such acts come within the reach of the statutes cited in this complaint. It is the U.S. Congress that has explicitly granted to federal courts in the United States the jurisdiction to hear such actions and to grant the civil relief they provide for. In 1988, Raisi was Deputy Prosecutor General of Tehran Province, whose activities were focused on two prisons in Iran, Evin Prison and Gohadash Prison. As to whether he committed the acts alleged in the complaint, there can be no doubt. In a famous meeting in 1988, a recording of which was released in 2016, Ayatollah Hossein Montazeri, the designated successor of the Ayatollah Khomeini, is heard addressing members of the death commissions, including Raisi, and telling them that they are guilty of the greatest crime committed in the Islamic Republic, for which history will hold them accountable. Raisi himself was one of 4 death commission members to whom Raisi addressed a personal letter, making the same point. And I believe that letter is in your materials. That letter describes the killings ordered by these death commission members, including Raisi, who was an addressee of the letter, as, quote, massacres without trial. Raisi has not denied his participation, and in 2018 he was quoted as saying that the murders committed at the direction of the death commissions were, quote, one of the proud achievements of the system. Because of the way these death commissions functioned, it is no strain to characterize the executions they ordered as extrajudicial. That word means simply outside any recognizable judicial proceeding, and the death commissions functioned by simply bringing prisoners before them and asking one question. In the instances involving members of MEK, that one question was whether they in fact adhered to MEK. The accused were permitted to speak only to answer that question. If the answer was yes, they were taken out immediately and hanged, sometimes in groups of as many as a dozen. By no stretch of the imagination was that a judicial proceeding. Indeed, the letter from Ayatollah Montazeri in 1988 that I quoted a moment ago, addressed to Raisi and 3 others, refers to these killings as, quote, massacres without trial. He said, quote, I am worried about the judgment that posterity and history will pass upon us. To be sure, there are some legal challenges to overcome. If Raisi claims diplomatic status and asserts diplomatic immunity from being sued, the United States is party to the 1961 Vienna Convention on Diplomatic Relations. Because the United States is a party to it, that convention is a treaty and has the force of law in this country. It protects individuals serving as diplomats from being sued here, with certain exceptions that may not apply. However, it should be stressed that it is far from clear that Raisi is eligible for the status of a diplomat. The convention itself defines a diplomat as the head of a diplomatic mission or a member of the mission. Raisi is certainly not the head of Iran's mission to the UN, and so far as we know, he has not been designated as a member of the mission. Also, the special treaty-based immunity of representatives of UN member states from civil suits is limited to acts done by them in their capacity as representatives. That's not what we have here. Finally, as a Belgian court found in the case of Asadollah Assadi, an Iranian diplomat convicted of trying to bomb a meeting of MEK, diplomatic immunity does not mean diplomatic impunity. Even diplomatic immunity has its limits. That's a brief description of the legal landscape, which can be further addressed by the talented lawyer sitting to my left who's handling this case and who is present here. But beyond the legal setting, there's also a political setting that may well impact the legal setting. For one thing, Raisi has the title of president and may claim to be a head of state. But one could argue, and I think more convincingly, that the supreme leader, Ali Khamenei, is the head of state. Indeed, President Obama said of Rouhani, who was one of the predecessors, one of the predecessor presidents, the Iranian president he was dealing with at the time, Rouhani did not have ultimate authority, and that authority belonged to the supreme leader alone. The issue of head of state status may be important because, as I will explain in a moment, there are political and perhaps legal considerations underlying the question of whether a head of state can be sued. The U.S. State Department has authority to decide whether, despite the fact that Ali Khamenei is the supreme leader, Raisi nonetheless could be regarded as a head of state. And if the State Department makes that determination and so notifies the court, that determination is binding. What will influence the Department of State in making that determination? What should influence them? Well, let's start with reality. The reality is that Ali Khamenei is the supreme leader and has been so regarded throughout the world for years. Indeed, even within Iran, Ali Khamenei is the one who decided that Raisi had the right to run for president, and that one of his predecessors, Ahmadinejad, did not. I think he should properly be regarded as the head of state, and a state should no more have 2 heads than a person should have 2 heads. We all know that the current administration and the Secretary of State appear eager to conclude an executive agreement with Iran relating to its nuclear program. This is not the time or place for me to explore the wisdom or unwisdom of entering into that kind of agreement, although I would note that in 2018, Israel carried out a daring raid in which it seized an archive of Iranian documents proving that Iran has pursued the goal of obtaining nuclear weapons nonstop since Khomeini came to power in 1979, even during periods when it was committed not to do so. Rather, my point is that it may be that the State Department would not wish to offend Iran by agreeing that Raisi is subject to being sued. As if the State Department is called on to express a view to the court as to Raisi's status, I would suggest that there are at least 3 additional elements beyond reality that should enter into its calculation. The question of whether its decision would please or displease a country with which it is seeking to conclude an agreement should not be one of them. One, of course, is something I mentioned a few moments ago, that the State Department itself in 2021 found that Raisi was involved in the commission of serious human rights abuses, some of which are the subject of this lawsuit. Another is the fact that the government of which Raisi serves as president is itself one of only 4 governments that the U.S. has designated as state sponsors of terrorism. But a third element the State Department should consider is that according to a complaint filed by the Justice Department, it was in October of 2021, 2 months after Raisi took office, that the Iranian government solicited people to murder former National Security Advisor John Bolton, former Secretary of State Mike Pompeo, and perhaps a third U.S. former official, apparently in retaliation for the attack in January 2020 that killed Qasem Soleimani, former head of Iran's IRGC, an agency designated as a terrorist organization by the United States. The murder of those former U.S. officials was to be carried out on U.S. soil. Based on the structure of the Iranian government, that plot would have had the approval of Raisi as chair of the Supreme National Security Council, one of two bodies involved with authorizing foreign terrorist operations. The other such body is the Special Affairs Office of the Supreme Leader Khomeini. According to documents that were filed in 1982 in a trial in Berlin known as the Mykonos trial, after the restaurant in which the murder prosecuted in that trial occurred, the President of Iran serves on the Special Affairs Committee of the Special Affairs Office. It would seem at least politically problematic for the State Department to extend head of state status to someone likely to have been involved in planning the murder of former U.S. officials on our soil. Now, beyond the legal and political setting, there's a third setting here that's relevant, and it's one you will hear about when the people who have suffered at the hands of Raisi have an opportunity to address you. And that setting is one that is supposed to underlie both the legal setting and the political setting, and that is a moral setting. Apart from other considerations, there's a basic instinct in civilized societies that says people credibly accused of doing what Raisi stands accused of doing should at least have a record made of their deeds, and ideally be made to confront and respond to that record. It's important to build that record in as many jurisdictions as possible so that the full picture of who Raisi is can emerge. The filing of this lawsuit is a step in that process, an important step. As whether it succeeds ultimately or not, it's important to try. Thank you very much.
Thank you so much, Judge Mukasey. Really appreciate the great overview you gave. I want to highlight 2 points you made. Diplomatic immunity does not mean diplomatic impunity. That's like the core of the issue here, and you cannot have two heads. With that, I want to now go to the victims or the family members to speak. These are the ones who are part of the complaint that's been filed in New York. Before we go to Professor Stephen Schneebaum, I would like to first start with Ms. Sheila Neinawai. As I said, she is a former political prisoner who spent many years in the Iranian prisons. Ms. Neinawai, please.
Thank you. Hello, everyone. My name is Sheila. I already did. Hello, everyone. My name is Sheila Neinawai. I'm an Iranian American living in Greater San Francisco Bay Area. I was arrested 3 times and spent a total of 8 years in various Iranian prisons. I was first arrested in November 1981 by the Iranian regime security forces when I was 15 years old at my home in Tehran, and taken to the notorious Evin prison simply for distributing the literature of the main Iranian opposition movement, the MEK. After months of torture with no due process, I was sentenced to 5 years of imprisonment in a trial that lasted less than 3 minutes. I was again arrested in May 1987, only 4 months after my release, and once more taken to Evin for another almost 2 years. This jail sentence coincided with the well-documented massacre of thousands of political prisoners in the summer of 1988. On August 15, 1988, I was taken to the death corridor and appeared before the Death Commission in Evin. When when I sat in a single chair in front of the 4-member committee, one of which was the current president of the regime, Ebrahim Raisi. I was among the very few survivors. After months of returning from my solitary confinement, I realized that most of my friends in prison had been hanged. And the prison, which was full when I entered it, seemed deserted and empty. I was released in March 1989 and was arrested again 2 months later in May 1989 and spent close to another year in jail. Eventually, as I was escaping Iran, I felt the responsibility of echoing the voice of my fellow cellmates and those who did not survive. My determination to be the voice of voiceless was the only force that kept me going. What I saw and experienced still wakes me up at night, and flashbacks brings tears in my eyes. Now, every time I hear the name of Ebrahim Raisi, I totally forget about myself and remember the pregnant woman who I saw being beaten when children as young as 2 years old running around and looking for their mothers, or crying because they were hungry. I remember the innocent faces of young girls who never made it out of the prison. For this reason, I chose to join the legal complaint as a witness and victim of Raisi's crimes against humanity and genocide. Now is the time for justice and accountability. Thank you very much.
Thank you so much, Ms. Nawai, for your very chilling recount of the story, what you have gone through and what everybody else, especially under Raisi, have gone through. Appreciate that. Now we're going to go to Mr. Ahmad Hassani, whose brother was one of the victims killed in 1988. Mr. Hassani, please.
Thank you very much, Mr. Jafarzadeh. I'm very pleased to be here today with you because I feel now some 34 years after I and thousands of family like me lost their loved ones at the hand of this brutal regime, justice may finally be served. Now that Ebrahim Raisi, the henchman of the 1988 massacre, is planning to visit the United Nations in September. My name is Ahmad Hassani and I am a Canadian citizen and originally from Iran. I'm one of the plaintiffs in this lawsuit against Raisi. My brother Mahmoud, which was born in Iran in 1960, was a student in Tehran University when he was arrested in 1981 at the age of 21 and was sentenced to 10 years in prison for expressing support for main Iranian opposition group, the Mojahedin MEK. He took part in MEK's rallies or distributed their newspapers to those interested. While in prison, he was tortured and abused physically and mentally. We were hoping that he would be released soon, since he had already served 7 years of his sentence. But we were shocked to find out that he had been hanged during the 1988 massacre, like 30,000 others, after refusing to renounce his support for MEK and the ideal of Iran's freedom before the Death Commission. Raisi is directly responsible for the execution of my brother, because he was a member of Death Commission in Tehran, which ordered the execution of political prisoners in Evin prison and Gohardash prison in Karaj, west of capital. We found out about my brother execution when the regime agent called my other brother, Muhammad, and asked him to go to Evin prison. While he was blindfolded, they took him inside the prison, and one of the agents told him that we executed your brother, and told him that your brother was a good man, but we have to execute him. They didn't tell my brother what happened to Mahmoud's body or where he was buried. The agent told my brother that you are not allowed to have any kind of memorial ceremony for Mahmoud, and gave him some of Mahmoud's belonging. I joined the tens of thousands of families of the victims and those who survived the massacre to demand accountability. The United Nations must launch an investigation. Raisi and Supreme Leader Khomeini must be prosecuted for crime against humanity. Thank you.
Thank you so much, Mr. Hassani. Well, we heard from the victims, from the families. We heard from Judge Mukasey, and it's now time to go to Professor Schneebaum, who is actually representing the victims in the complaint file in New York, and if there's any additional points that Mr. Schneebaum wants to add, we appreciate that. Please.
Thank you, Ali Reza, and good morning, everyone. I'm Stephen Schneebaum, one of the lawyers representing the plaintiffs in the case filed last week in New York City against Ebrahim Raisi, president of the Iranian regime. I want to take a few minutes to present an outline of the case, why it was brought, by whom, and under what authority, before opening the floor to your questions. It is beyond doubt that thousands of political prisoners were killed in Iran and countless others were tortured in the summer of 1988. And this was no random act. As has been explained, it was the direct result of a fatwa by Ayatollah Khomeini intended to eliminate opponents of his theocratic rule, and especially supporters of the Mujahedin Khalq. As many as 30,000 individuals guilty of nothing but principled resistance to the mullah's oppression were hanged at Evin and Gohardasht prisons in Tehran that summer. I say these facts are beyond doubt because they are. The massacre has been reported on and denounced by Amnesty International, by various agencies of the United Nations, and by our own Department of State. The MO of the executions was simple. Prisoners were hauled before a four-member body that has come to be called the Death Commission. They were asked some variant of one single question: do you renounce your support for the MEK? If the answer was no, they were summarily executed by hanging in groups as large as 12 at a time. The Death Commission was no court, of course. There were no lawyers. There was no defense, and no appeal was permitted. It existed for the sole purpose of providing legal cover for a planned mass murder. It is also beyond doubt that as Deputy State Prosecutor for Tehran Province, Ebrahim Raisi was a member of that Death Commission. This, too, has been amply and widely documented. He has on his hands the blood of those who were killed, as well as of those who somehow escaped death only to be tortured. And he has never been held accountable for his involvement in the massacre. This lawsuit is an attempt to do just that. It is filed against Raisi individually not against the regime, although it has amply earned its designation by the U.S. government as a state sponsor of terrorism. And it is focused on one specific event or set of events that occurred at a specific point in time: the mass killings and torture of political detainees in 2 prisons in Iran in the summer of 1988. The plaintiffs in this case, from whom you've just heard, are survivors of the massacre and family members of some of the men and women who were murdered. They are now citizens of the United States, Canada, the UK, Germany, and Switzerland. They have harrowing stories to tell, and this lawsuit will allow them to tell those stories in a court of law. 2 U.S. statutes are the bases for the action. One of them dates from the earliest days of this republic. In fact, it was signed into law by President George Washington in 1789. The Alien Tort Statute empowers federal courts to hear cases alleging injuries done to foreign citizens in violation of the law of nations. The second basis is of more recent vintage. The Torture Victim Protection Act of 1991 opens the courthouse doors to U.S. citizens who were or whose loved ones were tortured or illegally executed under color of foreign law. The plaintiffs allege that Raisi was personally responsible for committing offenses under international law and that he is therefore personally liable to his victims and their survivors. These violations include torture, extrajudicial killings, crimes against humanity, and genocide. Although all of those are also criminal offenses, this is not a criminal prosecution. It is a civil case initiated by the victims against the perpetrators of unjustifiable acts. Raisi will be served with process when he arrives in New York City in September to attend the United Nations General Assembly. Once he is served, he will have 21 days to respond to the complaint. If he fails to do so, the plaintiffs will seek a default judgment enforceable against Raisi or his assets. The judge assigned to the case has scheduled a preliminary hearing for the 15th of November. Probably Raisi, or someone acting on his behalf, will contend that he cannot be sued because he is entitled to immunity, either diplomatic immunity or personal immunity as a sitting head of state. But neither proposition is correct. Raisi is not a diplomat, as Judge Mukasey explained, and is not eligible for the privileges extended under the Vienna Convention. Nor is he, in fact, a head of state. Although Raisi carries the title of president, the supreme leader is the head of state of Iran, as the country's own constitution makes clear. So we believe that his immunity arguments will fail. Assuming that Raisi does attend the UN session this fall, he will be the only person in the room who is required by law to answer charges that he himself was responsible for horrific human rights abuses and crimes against humanity. Whether or not it ultimately proceeds to trial, through the filing of this case, the plaintiffs have already won some measure of vindication. They have invoked the rule of law and have invited their tormentor to respond to their charges in a court of law. While the killings were going on back in 1988, as you've heard, Ayatollah Khomeini's designated successor, Ayatollah Hossein Ali Montazeri, recognized what was happening and called the massacre the greatest crime committed in the Islamic Republic for which history will condemn us. For a crime of this magnitude, there has to this date been no justice. This lawsuit, brought by these plaintiffs against this defendant to be heard by a United States federal judge, is a small step toward that goal. My clients hope that it will be some solace to others around the world who were or whose loved ones were victims of the regime's lawlessness, crimes against humanity, and terrorism, and to know that here in America, the rule of law is alive and well, and that no one, no matter his title, stands above it. Thank you for your attention. I will be pleased now to try to answer your questions.
Thank you. Thank you, Mr. Schneebaum. No one is above the law. I certainly appreciate that. We're now going to go to journalists. Please introduce yourself. There's a microphone. And raise your question, please.
Thank you very much, Alireza.
Sure.
A question is posed to General Mukasey and to Professor Schneebaum. It would almost seem that there is precedent for taking a move like this in the cases of General Noriega, indicted when he was president of Panama and then later brought to justice when he was deposed, and the case of President Perez Jimenez of Venezuela, indicted and then finally deported to Venezuela when he was in exile in Miami. Have you looked at either of these cases from Latin America, and do you plan to use it?
We certainly have looked at those cases, and others, incidentally. The case of Noriega is perhaps not directly on point because the State Department officially proclaimed to the court that Noriega was not, in fact, a head of state. And under the Panamanian Constitution at the time, he was not. He was exercising extraordinary powers, but they were, according to the Department of State, extra-constitutional. The Perez Jimenez case similarly was not, according to the State Department, a sitting head of state at the time. Another case, incidentally, that is similarly instructive is the case of Radovan Karadzic, who in 1991 attended, of all things, a United Nations General Assembly meeting. And while he was in New York, he was sued under the Alien Tort Statute by a group of people, a group of women, who claimed that they had been sexually abused as part of the campaign of ethnic cleansing for which the Republika Srpska was responsible. And the State Department was asked whether Karadzic was entitled to head of state immunity. And in that case, the State Department said no, because it said the Republika Srpska is not recognized by our government, and therefore its head, whoever he might be, is not considered to be entitled to the privilege of head of state immunity. So in this case, as Judge Mukasey explained, the State Department may have several factors to consider. One is the simple fact that under the Iranian Constitution, the president is not the head of state. That's simply a fact. But beyond that, there are also the considerations that the government that he purports to head is that of a state sponsor of terrorism under U.S. law, and he himself is under sanctions specifically for having committed human rights violations, including the ones at issue here. So we think that the arguments before the State Department may not be quite so simple, and we are hopeful that the State Department will conclude that in this case, United States foreign affairs, foreign relations will not be negatively impacted by the prosecution of a civil case against a man who is not, in fact, a head of state.
Thank you so much. Judge, did you want to add?
No, I think that says it all, and succinctly.
Thank you so much for your time. My question is that what Raisi will exactly... Thank you. What Raisi will exactly face if he decides to come to New York in September, and what sort of tools do you have to keep him in custody? Do you have to first convince the State Department? How is this legally?
So, Schneebaum, do you want to start first, and then Judge?
Let's be clear about one thing that is very, very important about this case. This is a civil case. It is not a criminal prosecution. So he will not be detained in this country. He will not be forbidden from leaving this country. He will, however, be sued. And like anybody else who's sued, he has a set period of time within which to respond to the suit. In this case, because the suit is in federal court, he will be entitled to 21 days. At the end of those 21 days, he must either plead to the complaint. That is to say, he must either affirm or deny all of the allegations set out in the complaint, and you have the complaint in your packets, or he may move to dismiss the complaint on the grounds that it's not legally substantiated. If he does that, we will, of course, oppose that motion, and we will argue that motion before a federal judge in New York City, precisely where we want to be, because there the rule of law will govern. There the determination will be whether or not the murders that Raisi is responsible for constituted a violation of the law of nations. And I would argue if they didn't, then nothing does.
Judge, do you want to add, please?
Yeah, I would just add that if the case goes forward, he would be entitled, under the law, to examine, that is, to question his accusers, the plaintiffs in this case, under oath. But correspondingly, he too would be subject to being examined under oath. And if he refused to be examined under oath, his answer to the complaint could be stricken and a default judgment could be entered against him. So that's the way the law operates, and he is subject to it just like any other party.
And I want to add a couple of points. I think as the Professor Schneebaum and Judge Mukasey declared and in details, this is a unique thing that has been initiated already here. And think about it. Since 1988 until now, that's, over 30 years, 34 years actually, that Raisi, with all the killings, all the track record, all the continued torture and killing, has never been held accountable anywhere in the world. It's stunning to even think about that. And the fact that this is the start, this is the first case that a complaint has been filed, a record has been formed. Look at the complaint, the text of which is available to all the reporters who are here. It's chilling, it's compelling, it's focused on the issue of crimes against humanity and genocide, for which Raisi is directly responsible, indisputable, but was never held to account in anywhere else. And here is the opportunity. This is the first opportunity here in the United States and in New York, where the headquarters of the United Nations is. Thank you. So any more questions here? If not, we're going to go to online questions.